My name is Jennifer Stanton, and I'm an assistant Crown Attorney at the Downtown Toronto Crown Attorney's Office. And with me is Detective Constable Rebecca Sisk of the Toronto Police Service. And we will be hosting the webinar today. Before we begin our session, there are a few quick housekeeping points. For participants listening in French, click on Floor at the bottom left of the screen and then select French. To see and follow along with the PowerPoint presentation in English, click Presentation on the top left of the screen. To follow along with the presentation in French, download the French version of the presentation by clicking on Documents on the right. Feel free to download the presentation in both English and French by clicking on Documents on the right. There will be a question and answer period during the last 5 minutes of the webinar. To submit your question, please go to the toolbar on the right and click on Messaging and then Participants and type in your question. You can submit your questions at any time throughout the webinar. If you are watching this webinar in a group, please enter the number of participants in the group by clicking on Messaging and then Participating and then Participants. We will now begin our discussion. I will be speaking first, and then Detective Constable Sisk will be speaking afterwards. The topic of today's presentation is cyberbullying and sexting, legal responses, and practical tips. You may recall some time ago seeing this particular video on what became a profoundly impactful event having to do with the topic of cyberbullying. And ultimately, a number of events, including inspired and resulted in a working group. It was created by the federal government because there was a void in the law in relation to the specific action of what we term or understand as cyberbullying. And specifically, if you're not familiar with the introductory video, the interest and inspiration for creating such an offense occurred after two very high-profile incidents of suicide by young women who reacted in that fashion after intimate images of them had been shared without their consent. And ultimately, such actions resulted in the introduction of Bill C-13, which was termed Protecting Canadians from Online Crime Act, and it became in force on March the 10th, 2015. The then Minister of Justice, the Honorable Peter MacKay, made commentary in relation to what the concern was underlying and what instigated the creation of Bill C-13. And specifically, there was a concern and interest in filling the void of what then was in our criminal code. And specifically, the Honorable Peter MacKay, as he then was, explained what the concept of cyberbullying meant, in specifics an interest as a result of the number of teen suicides in the past years. But the way that the conduct particularly came about was initially in a fairly innocuous, non-criminal context. And non-criminal meaning the element of consent became particularly important in relation to the online distribution of such intimate images. And so intimate images usually were generated in a private setting in a consensual fashion. And that is putting aside any images that may constitute child pornography pursuant to the criminal code. But assuming that is not the case, these particular images were coming to be transmitted electronically pursuant to the criminal code. But assuming that is not the case, these particular images were coming to be transmitted electronically online in the context of a relationship being over or in the advent of the breakdown of the relationship. One of the parties, in some instances, who maintain control over the intimate image would, in a revengeful fashion at some instances, distribute those images to a third party or third parties without the consent of the person depicted in the image. And sometimes that has become known as, quote, revenge porn, end quote. And just skipping ahead, ultimately what occurred was the online distribution of intimate images without consent. The treatment of the courts in some instances have captured what is the purpose of this particular legislation. And in particular, the court in a case called AC, square bracket 2017 OJ number 2867, is such an example. And specifically, the court in that case explained that Section 162 encompasses a broad range of conduct. So, for instance, it may include a single image. It may include multiple images. It may include image that is it may include image that is distributed to a single recipient, and that could be by email or text. It could include a image that's distributed to multiple recipients, and even is the case that the image could simply be made available to an unidentified number of individuals, where it is simply uploaded into an online forum that is accessible by virtually anyone. At the core of the concern of this section is privacy and the ability for an individual to control access to private images of themselves. So, to be distinguished is the context where an intimate image is created with consent. An individual's privacy is violated when the distribution or sharing of that image is made without consent. And where the context exists that such an image is made available to virtually an unidentified number of individuals, the greater is the invasion of privacy. So, considering what are the elements of section 162.1 sub 1, which essentially addresses this larger notion of cyberbullying, the elements of the section are that everyone who knowingly publishes, distributes, transmits, sells, makes available, or advertises And some of that language is reflective. Some of that language is reflective of that involving other criminal offenses dealing with the online exploitation of children. But it goes on to include the definition or the language of intimate image. So an individual who does any of those things with an intimate image of a person, knowing that person in the image did not give their consent, or if the distributor was either reckless as to whether or not that person gave their consent to that conduct, and the conduct in that instance is the distribution. So publish, distribution, transmit, sell, make available, or advertise. Then that makes out the offense under section 162.1 sub 1. Section 2 describes specifically or defines what an intimate image is. And so for further clarification, an intimate image pursuant to 162.1 includes a visual recording of a person that's made by any means, and that includes a photograph, film, or video recording that is the person is nude, exposing his or her genital organs or anal region, or her breasts, or is engaged in explicit sexual activity. And it need not be all of those components, but the language of or is included in relation to any one of those components. Next is B, in respect of which of or is included in relation to any one of those components. Next is B, in respect of which, at the time of the recording, there were circumstances that gave rise to a reasonable expectation of privacy. And that speaks to the contemplation that such images depicting the intimate circumstances identified above could be consensual in the context of a romantic relationship. And sub C, in respect of which the person depicted retains a reasonable expectation of privacy at the time the offense is committed. So all three components form part of sub 2, meaning the definition of an intimate image. Sub 4. Sub 3 includes a contemplation of the public good exception that is also present in obscenity law. And it articulates that no person shall be convicted of an offense under this section if the conduct that forms the subject matter of the charge serves the public good and does not extend beyond what serves the public good. So that is the public good exception to the section. And finally, subsection 4 indicates that for the purpose of subsection 3, that it is a question of law whether the conduct serves the public good, and then goes on to say it is a question of fact whether the conduct does or does not extend beyond. And in this instance, the motives, and so specifically in relation to the concept of the public good exception of the accused, are irrelevant. So looking at that particular section, I've identified some of the important elements, but also unique features of the section. So first, in terms of the elements essentially capture what are the components of the offense under 162, which we've already discussed in some explanatory fashion. So the accused did something as articulated with the image. The image was an intimate one, meeting the definition in sub 2. there's a lack of consent to the conduct, and the accused knew or was consent. In terms of the interesting features, clearly included within the definition of this in the section is that explicit explanation of what an intimate image is in this context. As I indicated, there is a public good defense included, which is reflective of that in obscenity law. And it also acknowledges the concept of a reasonable expectation of privacy. What is distinguishable from this offense, although much of the language is reflective or reminiscent of that other elements of the criminal code pertaining to the online exploitation of children, such as child pornography offenses, there's no requirement with respect to age, as would be the case in relation to age. As would be the case in relation to child pornography-related offenses, where the subject must be or depicted to be under the age of 18. Other interesting components of 162 relate to a matter of sentencing. So first, there's no mandatory minimum sentence associated with a conviction under that particular section, as is the case with a number of other offenses, specifically those pertaining to child pornography, although a number of those mandatory minimums at this time are being constitutionally challenged. The maximum sentence on a summary conviction is 12 months, and where the Crown proceeds by way of indictment, the conviction is 12 months, and where the Crown proceeds by way of indictment, the maximum sentence is 5 years. There is no SOIRA order attracted by this particular section, and that is the same of a 161 order. However, the section has as its own component a version of arguably a 161 order under section 162.2 sub 1, which imposes in a prohibitory fashion some of the concerns addressed by 161 orders. Similar to the case of a number of online exploitation or child pornography related offenses, 164 sub 2 allows for the forfeiture that house the intimate image or images in question. And finally, a freestanding restitution order may be made in relation to the cost of removing any such images, either from a device online or other means, pursuant to section 738 of the Criminal Code. Section 162.1 is a relatively new offense, and its treatment in case law is reflective as such. This is also acknowledged by the court in JTB, citation square bracket 2018 OJ number 2018. The court in JTB acknowledges the rationale or concern underlying 162.1, and in particular the impact of the distribution of an image or images in the context of the internet, and essentially the complete inability to contain the rapid and expansive distribution of such images once they are uploaded or made available in an online context. And this is reflective very much in terms of the psychological impact, where victims of such crimes are aware of the fact that their intimate image is being accessed in an infinite kind of way. The same sentiment is articulated in a number of fairly recent cases post 2015. As is the case with any offense that deals with the online exploitation of children, deterrence and denunciation are paramount sentencing goals in relation to 162.1, meaning, regardless of other sentencing principles which are at play, deterrence and denunciation must be given paramount consideration by a sentencing judge. Part of the concern and what is the effect of the re-traumatization encountered by a victim whose image is uploaded online. And in particular, I have included an excerpt from a victim impact statement that was considered by our courts. And this particular victim is able to articulate precisely what the re-traumatization constitutes in relation to the knowledge that her intimate image has been made available to an infinite number of people perpetually and in perpetuity. The court explains that the victim says her, quote, online presence cannot be controlled, end quote. And she is, quote, perpetually and in perpetuity. The court explains that the victim says her, quote, online presence cannot be controlled, end quote. And she is, quote, out there, and there's no coming back from that, end quote. And finally, quote, it is something that will follow her for the rest of her life, end quote. It has had an effect on this complainant's personal dignity and self-esteem. Trying to grasp and understand or deal with the concept that people who are unknown to her seek interest or possibly sexual gratification from her own personal abuse or violation. She encounters people, she wonders if they too have seen her image online. And it articulates essentially just how vast and ongoing the impact is for a victim of this particular offense. The ongoing nature, the permanence, the lack of prevention, and the profound violation to this victim and other victims' privacy are all concepts recognized by our courts. I had indicated earlier what is the prohibition or internal prohibitive language of 162.2, or in other words, while this particular section does not allow for a 161 order, its own internal version of a 161 order is encompassed within section 162 sub 2 of the Criminal Code. And the language is captured on the screen right now. It articulates that for a maximum of 20 years or another period of time that the court orders, that there will be a prohibition on the use of the internet or other digital network, except with the exceptions that are articulated in the section. And so in particular, it's reflective of 161 sub D of the Criminal Code, or relates to some of the behavior that a recent case of the Ontario Superior Court of Justice is in the case of Jonet, which is a citation of square bracket 2019 OJ number 1342. And the court in this particular case used strong language that, and this is not a 162.1 case in particular, but the court attempts to articulate, and does so quite well, what the impact of the online circulation or distribution of intimate images or videos. And there's acknowledgement for the fact that this cycle of offense essentially cannot be eliminated from circulation once an image has been uploaded online. The court finds that the harm is both acute and perpetual, and the growing number of victims, most identified because, as I indicated, this is a child pornography case, suffer from wounds that are continually reopened and harm that can manifest itself over decades. And again, it's the concept of the redistribution and inability to contain the spread of an intimate image once in an online forum. Not necessarily specific to intimate images where the victim is identified, but general sense, one new trend is the incorporation or presentation of community impact statements in the sentencing proceedings before our courts. And specifically, Section 722.2 sub 1 of the Criminal Code provides that not only can a victim identified in the online related offenses can make a victim impact statement, but the community at large, or different communities recognized by the courts, are permitted, pursuant to that section, to file a community impact statement to describe what is the loss suffered by the community as a result of the commission of a particular offense. And this is particularly related in the context of Section 162 sub 1, given the community's concern for the results in some instances, which have been extremely serious. By way of example, suicide, where the offense of cyberbullying is committed, and particularly in instances where the victim is young, a child or a young person, where the individual is vulnerable, so someone who is taken advantage of or exploited in some way such that their intimate image is being used as a form of quote-unquote revenge porn, the impact that the community that these actions have on the community when vulnerable members are being affected by such crimes as they are. Such a community impact statement was considered by the court in the case of Jonet, which was previously mentioned, and specifically the court acknowledged that these statements, and these are referring to community impact statements, provide a means of gaining a deeper understanding of the deep and lasting impact upon such victims that his behavior has contributed to inflicting. And so while we as a society can, in an abstract way, impact that knowing an intimate image has been circulated and will be circulated perpetually would have on a person, impact statements and community impact statements reflect and allow our courts to have a deeper understanding about the psychological and emotional impact that this has on real people, on individuals. So much so that in some instances, the results are fatal. And at this time, I will be passing the presentation over to Detective Constable Sisk. And after that point, we will address any questions that you have.
Okay, good afternoon. I would like to just go through some definitions just so that we're all on the same page of understanding what they all mean. These ones that I have on the screen are from the Canadian Centre for Child Protection. The Canadian Centre is in Winnipeg, Manitoba, and it is a national charity that is dedicated to the personal safety of children. So they describe sexting as youth creating and sending images, intimate images with each other, and it's over an electronic device or the social media. We would also add that it also includes the sexualized chats that the youth are engaging in with each other, and it is consensual. Sextortion often happens when sexting has already occurred and one of the youth is asking the other youth for more images, maybe more graphic images, or just something different. And there's consequences for not satisfying that demand. And those consequences could include uploading the previously sent images that they've already shared, or uploading intimate information that they've already shared with each other to the internet or social media accounts that the victim would have a circle of friends or family attached to. So it is a combination of extortion with sexting images. And cyberbullying, it's a form of extreme bullying that is targeted, it's abusive, it's deliberate and repeated behavior, and it is intended to cause damage and harm to another person. And it is intended to cause damage and harm to another person. It does not need to be repeated, however, for a youth to come forward or for it to be considered as cyberbullying. This again is a definition from the Canadian Centre. But for youth, it's often combined with a sharing of a sexual image online. There are often many comments that are made by other youth about the uploaded image that causes a huge impact to that victim. Other forms of cyberbullying would include sending mean or threatening emails or text messages to somebody, posting embarrassing photos of someone online, creating a website to make fun of others, pretending to be someone by using their name, tricking someone into revealing personal or embarrassing information and sending it to others, spreading lies and rumors about someone to others. So why is this happening to our youth? Why are our youth sexting? The Canadian Centre has identified three main reasons. However, I like to include the development of the teen brain just a little bit to fully understand what is happening. It's the amygdala versus the frontal cortex dilemma. The amygdala, which is responsible for immediate reactions, it develops early on, and the frontal cortex, however, it develops much later on into the mid-20s, and it controls reasoning and judgment and thinking through consequences of behavior. So as you can appreciate, the teen brain is operating fully on the amygdala, and they are responding impulsively, immaturely, and quickly and emotionally because of that. So keeping that in mind, in sexting, the three main reasons that our youth are sexting, the first one would be romantic or sexual experimentation. And quite frankly and simply, this is how our youth are experimenting sexually. This is how they are exploring their sexuality. It is sometimes in lieu of sexual activity. Some youth have said they engage in sexting because they avoid the risk of becoming pregnant or contracting an STI, and they also get to maintain their virginity. Um, Sometimes sexting occurs to hopefully initiate a relationship with the other person, but it also is quite common in a relationship among youth. It was mentioned before how it is common for some of these images to be released or distributed after the breakdown of a relationship. However, we find as well that it occurs during the relationship. So there's an issue where our youth are not quite fully appreciating the seriousness of their actions, as far as it could be during the relationship when, say, the boyfriend has received some images of his girlfriend and he would like to boast perhaps and send them off to his friends. That often happens, we find, but it also happens as more of a malicious attempt to hurt or cause harm to the party who has maybe broken up with them. A second main reason why our youth are sexting is pure attention-seeking behavior. The first example is for the youth who is looking for attention not by their own images but by the images of other youth. These images they have either acquired from other peers, or they have taken the images themselves, and they are looking to get a laugh out of them, to get recognized for being funny and drawing attention and popularity to themselves. The other way is for a youth to take images of themselves and self-exploit themselves online. So the other way is for a youth to take images of themselves and self-exploit themselves online. So this would be, for example, we have seen youth who have created websites or social media accounts in their name. They have their age, their pictures, and it is with the intention to share and trade images or videos with other people. And the third reason why we have some youth that are sexting is it's coercive. So sometimes during a romantic relationship with our youth, one youth may be pressured to send images to the other person. And sometimes that pressure might cross the line and become pure extortion, really, or sexes. Maybe the relationship will fall and the partner will leave them. There could be that kind of threat, or a threat of the previously sent images being distributed online. The other way that this can happen in a coercive circumstance is could happen to a intoxicated youth at a party where they don't know that their images or videos are being taken when they are in an intimate scenario, like in a sexual act, or maybe in the bathroom or in the locker room sort of scenario. And those images are then sent out on the social media. What most of our sexting images and videos have in common, and what the underlying issue is from a police perspective, is that most of them are consistent with the criminal code definition of child pornography. And to just briefly speak to that, it is any picture, whether it is drawn by hand or by a computer, made by a computer, then it is a picture of a person who is depicted or is actually under the age of 18 years. And it is that person is engaged in or is depicted as being engaged in an explicit sexual activity. The other part can be that the dominant characteristic of that image is for a sexual purpose, the sexual organ or genital region, anal region of that person. And sexual organ here also includes the breasts. We also add that this child pornography can also be by written word and audio. So the sexualized chats among youth can also constitute child pornography as well. Basically, anything that's written that advocates the sexual abuse of children can be deemed to be child pornography. Luring is when any person commits this offense by who uses a telecommunication device to communicate with a person under the age of 18 years for the purpose of committing another offense with that person. And some of these, for example, are dependent on the age of the youth, whether they're under the age of 18, 16, or 14. It can be for to make child pornography. It could be to have sex with that child. It could be to engage in an indecent act with that child. But to be clear here, this is not referring to the creepy man in the van that pulls up to the children on the sidewalk, offering them candy to lure them into the van. So it's not only the adult who is preying on a youth, this includes youth preying on youth. We have encountered 12, 13-year-olds who have used a computer to lure other youths and to extort them for intimate images. So how do the Toronto police react to a sexting incident? These are some guidelines from the Canadian Centre for Child Protection, but these are in their educational material and on their website as well. So first, what we would have to look at is the degree of sexual explicitness of the image or video. So for example, is the victim or is the child in the picture wearing a bikini or bra underwear versus is that a video of an explicit sexual activity versus is that a video of an explicit sexual activity that is of a youth. The other part of that is it a consensual act happening in that video? And is that victim or youth aware that that image or video has been taken of them? So it's multifaceted. We have to ensure that the picture was consented to being taken, the sexual act itself was consensual, and the nature of the actual picture. Then we look at why was this image or video distributed online? Was it the impulsive, immature child who just reactively sent this out to possibly get some attention, or was it someone who made a calculated, malicious decision to send this out in the hopes of harm and hurting somebody else? So there's a big difference there of how we would react to that. The other thing we would look at is the extent of the distribution of that image. Is it to one person, like a private message, or is it to a wide form of people? Then we would look at once we establish foolishness, or if it's malicious, we would know which way to approach it. Are we going to investigate it from a complete police perspective and do statements and execute search warrants, or is this going to become an educational piece for the youth and their family? And oftentimes it does result in education. Education to both the affected youth who has had their images uploaded, and also to the acting out youth who has sent these images out. We would also ensure as much as we can that the images are deleted from any device that we know of, and we would caution everyone involved so that they are aware that the images that they are possessing are child pornography, or if they distribute that image further, that they could be charged with distributing child pornography or distribute an intimate image without consent. That this isn't just a fun game that some of them think it is. This is a serious police matter, and criminal charges could result. We also advise them that there is a Toronto Police report submitted, and it is a permanent record of what has happened. So if it were to occur in the future, that we have a document of that, and the next time it may not result in education only. And we also ensure that the affected youth and their parents are offered counseling through Boost. This is important because of it is a huge devastating thing to know that your images, yes, are being circulated online, but we also find sometimes that the youth they are enacting in risky behavior because of underlying issues. And it's important that we get to the bottom of those issues to deal with those issues and to prevent any further risky behavior online. For example, we have seen some male youth who have been coming out. They're afraid to come out with their homosexuality with their family and their friends. It's not a positive space to talk about that, about sex and exchanging intimate images with them. And so it spirals from there, and the police are often involved. And as far as what their charges would be when we caution them, yes, there's not actually a cyberbullying charge or a sexting or a sextortion charge, but we do tell them about the child pornography charges and whatnot, like distribute intimate image without consent, luring, even if it's a cyberbullying only issue where there's repeated actions against somebody, then they can be charged with criminal harassment or intimidation, threatening. So if you are in a position where you are dealing with youth and trying to steer them in the right direction, what we try to tell youth in a proactive and a reactive way is to not use any identifiers of themselves on their social media accounts. For example, to keep their name, their real name, their date of birth or address or actual age, and keeping their face out of the pictures and social media profiles. We advise to use their highest security settings so that the general public cannot access their accounts, thereby running a risk of being messaged by a stranger. We also hope that they would and encourage them to only know people or follow people that they know in real life versus just accepting any stranger's friend request. It's also important to go back to the basics and talk to them about the basic footprint, the digital footprint that they leave behind, that every image that they post, a stranger's friend request. It's also important to go back to the basics and talk to them about the basic footprint, the digital footprint that they leave behind, that every image that they post, every word that they send is forever. They cannot undo what they've done. That image or that chat that they engaged in, that text message that they sent, can be screen captured, can be forwarded, can be saved for down the road. Basically, they have no control once that picture is sent or that message is sent, and that can have some huge repercussions for them down the road, as far as social life, academic life. Even some employers could find this relationship or could find this information down the road. think we had it there. And something else in Center for Child Protection that offers age-specific documents that have indicators of what a loving, healthy relationship should look like versus a controlling, unhealthy relationship. And we also like to discuss with our youth proactively as well, who is in their safety net, who can they talk to if they were to become in a situation where someone has asked for an image or is asking them to do something that they are uncomfortable with online. Their safety net may not include their parents, so sometimes it's hard to think outside that box. So encourage them to speak to a teacher, someone that they trust, like a tutor or a coach, a favorite aunt, that sort of thing. This is just a list of some of the online resources that we have. This is just a list of some of the online resources that we have. I have a list that I have compiled and I would be happy to share it with you after the webinar. It is by no means exhaustive, but if you would like to send me some that are not included on the list, I would also appreciate that. This is an example of some of the educational material that comes out of the Canadian Centre for Child Protection. Some of these documents and brochures are downloadable from their website, or you can order them online as well. We make youth and their parents aware of how can they report something that's happened online. Cybertip.ca, needhelpnow.ca, and even just Crime Stoppers. And so a lot of these different websites are a huge benefit to some of our youth and definitely our parents, because our parents are. Take some questions and answers. I think we have some time. Okay, if I can also add one thing too that we like to discuss with parents, and unfortunately it's after a sexting incident, we talk to the parents about safeguarding from that point forward. And it is sometimes about instilling new rules in the house with the cell phone. It is having the parent armed with the password of that cell phone of their child, and it is imploring on them to conduct random checks of the cell phone and having the child use the cell phone or other computer devices in a common area of the home. Make it a rule to not have any computers in the bedroom or the bathroom. It has been my experience and many officers' experience from my section that have seen self-exploitive videos being made in the bathroom or the bathroom. It has been my experience and many officers' experience from my section that have seen self-exploitive videos being made in the bathroom with mom or sister, brother knocking on the door trying to get in. We say that these rules may not fix everything, and it may not guarantee a further sexting incident, but it may be a way to mitigate some of that harm. So someone does have a question. Do I read it out then, or? Yeah. Actually lost it there. Sorry. There was one at the top. That's the first one. Sorry. There it is, right there. So thank you for your time. I have a few questions. In the case of adults luring children and or youth online, are more cases the adults are known to children, or are they mostly strangers? That's a difficult one. The adults are known to children, or are they mostly strangers? That's a difficult one. Do you want to go for that first, Jennifer?
In relation to that question, there's not any statistical information that I have that would put me in a position to say there's more of one than the other. But I will say that in terms of case law where the question is, where it is adults luring children and youth online, are they known to the children or not? Either is entirely common. So it could be a case where the adult has some familiarity with an adult is able to look at aspects of their online identity and then pose as an individual who is like-minded or interested. And some adults present themselves as completely fictitious characters online in order to develop relationships with children and possibly even groom them. So I don't know if you...
I would say the same. It's common for both ends that they are known to the child and not. It's to say that it's only by strangers, it's definitely not the case. The next question.
Okay, so the next question is, in the case of cyberbullying and sexploitation between youth, do you find most cases are boys exploiting women or women exploiting women, etc.?
That can be, I don't think we have one versus the other. I think for the majority of sexting incidents themselves, we find that it is the in a boyfriend-girlfriend relationship, and the boyfriend is sometimes the one setting them out. But exploiting, where did that go? It can be boys exploiting boys or girls exploiting girls. There's no, I cannot have any stats on that as well. Okay. There's one here. How would you advise kids about reporting? Like I was saying about the safety net, they can report it to someone that's in their safety net, or some of those websites, if they have knowledge of those websites, or how would they report that anonymously, that sort of thing.
The next question is, does the criminal code follow the same definitions for cyberbullying, sexting, sextortion as the ones provided today? So in short, the criminal code does not identify those or define those particular terms. There's no criminal offense called cyberbullying, sexting, sextortion, or anything like that. There are related offenses that Detective Constable Sisk included when she was speaking. Those include extortion, which could capture sextortion, but it's a broader term. Extortion. Other offenses include those that are child pornography related offenses, online offenses like luring, criminal harassment can include some of the online offenses. And then section 162.1, as we discussed today. So it is more the case that those concepts are incorporated into broader criminal offenses. And it's 1:59. Okay. I think we're going to have to end our session for now. So if there's any further questions, we weren't able to get to all of them, please email us. The contact information is included at the end of our presentation. And thank you.